I don't need to make that comment until we have him back, so.
Really?
Yeah.
I go by James or Jamie. My grandfather was James.
All right, we're going to get ready to start. We had to do some rebooting for our virtual attendees. Some of them, I think, are back on. Some of them hopefully will be rejoining. This is our ethics hour. I'm very happy to have a good panel and I think some interesting topics. To my very far left is Doug Adelsberger from Adelsberger and Clevin in Fort Wayne. He's done this with us many, many years in the past, and I'm glad to have Doug back. In the middle is Judge James Ayler, the judge in Hammond. To my immediate left is Dan Witten, an attorney with Witten and Witten, and I'm Paul Shale, trustee from Hammond. So what we're going to do, we've got a couple different things we're going to do. The biggest share of the time we want to talk about attorney surrogacy issues. That's something we've never ever talked about. It became fairly relevant in at least a couple offices in our area over the last year, and so we thought that might be an interesting topic. After we talk about that, we've got 3 or 4 smaller topics of interest having to do with working remotely, secure communications, and those sort of things, and so we'll talk about those. As always, if you have a question, where's Cindy with the mic? Somewhere we have a microphone. Stand up and we'll make sure you get your question, but there's a microphone around that's available. We're happy to have you ask a question about it as you think of it. Save it for later. Also, if you haven't done so, if you have questions for the 3 o'clock panel, ask the judge, ask the trustee, please fill those out and drop them off in the box before or during lunch so we can get those put together for that panel. So, surrogacy. Yeah, let's see here. Doesn't seem to want to work. I'll do it the old-fashioned way. What does it mean to have or to be a surrogate? We're going to talk about what is a surrogate, who needs one, who can be a surrogate, and who should be a surrogate. What does a surrogate attorney do? First of all, let's start with where does the rule come from? The rule comes from the Indiana Rules for Admission and Discipline of Attorneys, Rule 23, Section 27, and that's attached to your materials. Let's talk about the first question, who needs a surrogate? Attorneys in solo practice. We have sort of a real live surrogate with us here in the form of Dan Witten. And Dan, you're not in solo practice, but you had a friend that was in solo practice that asked you to be a surrogate. You want to tell us a little bit about that and what you thought it meant?
Sure, I'm happy to do so. So, as I was sitting here getting ready to start this can't hear?
Yeah, move yours a little closer maybe.
How about now? As I was sitting here thinking before we started, I remember just a year ago, I was sitting out there. And I never would have dreamed in my wildest imagination that I would be sitting up here a year later talking about surrogacy. It wasn't in my mind. I wasn't thinking about it. My friends weren't thinking about it. And there was nothing that would lead us at that time to even consider it. So, what a long, strange year it's been. As I talk about surrogacy, I thought, where do I start? And I thought a good place to start for me is at the beginning. And for me, the beginning was Thanksgiving of last year. My closest friend and confidant and fellow attorney, Kevin Schmidt, called me to tell me that he thought he'd been exposed to COVID. We're all dealing with COVID at that time, so we were hoping for the best. Well, Kevin got sick, and for some time he was hospitalized. So I called downstate, and I said, hey, my friend's practice is in Maryville, and he's ill. What am I supposed to do? And they said, well, let's check. Did he have a surrogate? And I said, well, gosh, I don't know. And they said, well, let's look. And they put me on hold, and they came back and they said, well, we got good news and bad news. The good news is he has a surrogate. The bad news is it's you. So then I remembered the conversation that my friend and I had some years back when he asked me to be his surrogate. I had no idea what it was. So we talked at that time about all kinds of possibilities that I would do if he got sick, if he were sick for a month, if he were sick for 3 months, if he wanted to wind down his practice and needed help. At no time in that conversation did we go to the point where he isn't coming back and he's not there to tell me what to do, right? So we really didn't get that deep into the weeds. And it's one of those times in my life that I wish I could go back, and I wish I could ask questions that have come up since, because I just didn't anticipate them happening. And I'm saying that because if you're ever asked to be a surrogate, you really need to explore all possibilities, because you're truly in for a penny, you're in for a pound. And here's what I mean by that. And I could go through the rule, and I could tell you, you could read, section 27 of the disciplinary rule 23. You'll get it, right? It's a little bit confusing, it's a little bit ambiguous, but you'll get it. What I thought I might talk about today for a few minutes is what really happens when it's boots on the ground. So trying to figure out what a surrogate does in the short run, because I expected my friend to come back, I called downstate again, and I said, well, what do I do? The first person told me, well, you're his surrogate automatically because he designated you. Turns out that wasn't true. And they gave me some thoughts that really didn't apply to a bankruptcy practice. All the things they were telling me were more applicable to things like a family law practice, a PI practice, some real estate attorney office. They really didn't have a great deal of answers for a bankruptcy practice, much less a volume bankruptcy practice like Kevin had. So I didn't get a tremendous amount of help. And in fact, when I was talking to them about the real questions I had, like how do I handle these cases, and how do I handle these confirmation hearings, and how do I handle this, and how do I handle that, they said, well, oh my gosh, it doesn't sound like, this is their words, a bankruptcy practice really fits in very well with our rule. That's the answer I got from the state. So thankfully and luckily, during that time, Paul and Judge Ayler and Judge Lindquist, realizing the sheer volume of what was going on, we had a number of meetings. And it was a lot of trying to really figure out how this can work. One thing that I learned was you're not just a surrogate because the person puts you down as their designated surrogate. You don't get the immunity of being a surrogate that the rule allows you until you are court-ordered to be a surrogate. Now, I thought, logically, Kevin's office was 100% bankruptcy. The proper court to issue that order would be the bankruptcy court. Turns out that was wrong as well. The rule contemplates that order appointing you surrogate from a court of general jurisdiction, or they call it a court of competency, which in the county where the office is, which in Lake County is the circuit court. So I had to put together a petition for surrogacy, send it to the circuit court. The judge there was great, but she hadn't really encountered this before either. So everybody was kind of trying to feel our way through this. To make matters worse, I wasn't sure if I was holding a seat for Kevin to come back, which is what I was hoping for, or if we were in for the long game. And if I was holding a seat for my friend, how long was I holding it? We didn't talk about those sorts of things. I didn't know if Kevin was going to be sick for a year. Did he expect me to keep his practice running for a year? Did he expect me to wind it down? So that was a problem. Well, the story tragically ended with Kevin passing, and now I have 700, 800, 900 open Chapter 13 cases on top of mine. So suddenly I find myself dealing with 1,500 Chapter 13 cases that I didn't expect to get. So that became a real problem. And the biggest hurdle that I had was the rule contemplates or requires that I give notice to all of those clients, so 700, 800, 900 clients of Kevin's, about the surrogacy. That's a daunting task. Well, luckily, in our meetings, and with the help of Chris Totoro, they were kind enough, the clerk's office, to docket my order appointing me a surrogate so that all of the clients got notice from the bankruptcy court clerk. That was a huge, huge burden because that's a lot of people. But the problem then became, okay, I'm the surrogate for these 800, 900 clients. I have my own practice. I'm just a surrogate. I'm not their lawyer. I have an obligation, as you read in the rule, to get control of their files, to make referrals, to explain certain things to them. Technically, they're pro se, but they get the order saying, I'm the surrogate, right? So the first, right out of the gate, the first clients, the wife calls my office in Portage and says, I want to come in and talk with you. I got this order. She comes in and says, I see you're my lawyer now. So I explained to her what a surrogacy is. I explained to her that I'm not her lawyer now. I explained to her what my role is. She leaves. Next day, her husband wants to come in because she tried to explain it to him. So he comes in. We have an hour-and-a-half discussion. I explain the whole thing to him, what a surrogate is, more importantly, what a surrogate isn't. And he leaves. A day or two later, they both come back because they still don't understand it. Well, what do you mean? If you're not my lawyer, I got this piece of paper that says you're my lawyer. No, it says I'm the surrogate for your lawyer. So I finally I said, you know what, guys? Do you want me to be your lawyer? Because it's easier that way. They did. We got a contract signed, got my appearance on file, felt good about that until I realized that's one. There's only about 899 more to go. So for me, as I explained to the courts, the judges, as crazy as it sounds, it was easier for me to just contact these clients and say, do you want me to be your lawyer? I can refer you out, or I will be your lawyer. And with the help of Amanda, who's sitting over there, my right hand over at the Maribel office, we got them in. It's easier for me to enter my appearance and shepherd their case to the end than it is to explain to 900 people what a surrogate is and what a surrogate isn't. So my suggestion is if you're going to be a surrogate, beyond the initial don't, I would say have a conversation with the attorney that wants you to be his or her surrogate. And I would make that conversation even about uncomfortable things. Things like, what happens if you die? And what do you want to have happen with your staff? And what do each of them do? Because I got to tell you, if it's a volume practice, there's no time for a learning curve. It's not like our regular practices where we know over time what each one of our staff members' strengths and weaknesses are. You're stepping into an environment that you don't know any of those things, and you have no time. You have no time. Calls are coming in now. So my advice is go into the weeds with that person. Talk about the structure of their office. Talk about the strengths and weaknesses of their staff members. Talk about the kind of issues that come up in that office as a matter of course, so that when you step into that role, you're ready. At least you know the groundwork, because I did not do that. And it made it a whole lot harder. So those are the kind of things. Compensation. That would be something I would discuss with that attorney. How do you want compensation to flow? If you're off for a year, and I'm going to run, for all intents and purposes, your practice because you're sick, how do you want me to get paid? Because I want to be sure that we understand one another as to how that's going to work. Because when you come back, I don't want there to be any strange or weird misunderstandings. I'm doing this because I want to help you. You're doing this because you trust me to help you. Let's make sure that when this story ends, we all understood going in how it was supposed to end. That's something I would discuss. And here's the interesting part. If it's obviously a sole practitioner, as Paul said, they're the ones that are needing to designate a surrogate, you might want to tell that person, have a conversation with your family about what you expect. Because, you know, if a lawyer's been around a long time, even though it's their law office, their family might think it's a family business. They've been involved. They've been doing things. Maybe they're doing the books. Maybe they're doing the cleaning. Maybe they're picking up the phone and scheduling appointments. Who knows? But you don't want to be dealing with a family member after the fact, trying to explain to that person what you think their loved one, who they're still grieving, would have wanted or would have expected you to do for them in that practice. So those are the things I would have in my mind if I were considering doing a surrogacy, and I would get a real good handle on the caseload, because I did not. So when Kevin asked me to be a surrogate, I flippantly said, sure, I'll do anything. You asked the right way. I didn't think about it. We didn't even get into what his caseload was. I mean, without the office in Maryville, I don't have the staff to run that volume of cases. I need the Maryville office to continue running, to manage that caseload, because it's daunting. It's daunting. So I think that's what I wanted to really get across. And I'm happy to answer any questions, or the other panelists want to jump in here.
If I can, Paul. Dan, when you're talking about a volume practice and a number of people in the Chapter 13 debtors law firm practice, certain people, certain paralegals would have duties to do ABC, certain DEF. The ethics code, or the model rules, talk about how lawyers are the managers of the paralegal, and the buck stops at the lawyer. How does that, when you walk in as a surrogate, since you are not the lawyer for the client, how do daily things happen, or should they happen, until such time as you are ultimately made their lawyer, or the client does something to change to another lawyer?
So if once you're properly ordered the surrogate, you get some degree of immunity, so long as you lose that immunity when you enter your appearance. So during that time, and that's why it's important to follow through and get the order of surrogacy so that you can maintain that immunity. To do the things that the rule expects you to do. You have immunity to, you're notifying the clients, you're taking control of their files, you're getting them to a referral so they can be represented. You're explaining to them what it means to be pro se. You're perhaps taking control of the trust account, if in fact there is a trust account with money in it. So all of those things that you're doing more, though, interestingly enough, seem to gear itself toward a wind down of the practice, which again, if you think about the rules of surrogacy, if I'm going to be a surrogate for somebody who's got, I don't know, 15 cases, or they're a real estate attorney, or they're a divorce attorney, and they've got $20,000 in the trust account they're billing against, and they've got 24 clients or 36 clients, I mean, that's a little simpler to understand, right? It's a manageable caseload. You're going to get them somewhere where they need to go. You're going to wind down the practice, and your life's going to move on. The problem with, as I said earlier, with this situation was there just was too many clients for me to do that with. It was easier for me to understandably say, I'm going to enter my appearance on your case, which might be 2 years in, 3 years in, might have been filed just before my friend got sick. I'm going to enter into my appearance in this case knowing I'm going to lose my immunity as a surrogate, and I need to be making sure that I have a handle on your case, because once I enter, if there's a landmine in there, it's mine. So that would be, I hope I answered your question. Is my long-winded answer.
How did you handle the communications part of it? For example, it's not just a client coming in, and that traditionally that's what you may think of, but you may have a dozen, 100 clients emailing people, and you've got to grab that email account or text messages or things, communications you may not even know exist. How did you go about trying to gather some of those things together?
So I had, I heard you.
Okay. How did you grab a hold of the vast amount of communications? Because how did COVID or the pandemic really play into that? Who did it?
So yeah, that's a great question in the sense that on top of all this, we're dealing with trying to work our practices anyway through the COVID pandemic we're dealing with. We're all trying to figure out how to manage communications with clients, understanding we want to be safe and practice a safe, practice at our offices and all that sort of stuff. But I had the benefit of Amanda over there. So Amanda was Kevin's right-hand woman, if that's politically correct to say, and at his practice. So the clients that Kevin had were familiar with and comfortable with Amanda. So for me, she was my point to call them and set up the communication with me and them, and explain, so we could explain the fee agreement. So if I didn't have Amanda over there, it would have been probably impossible. So having the continuity of the staff that the clients were comfortable with, start reaching out to them, getting them in, and we just had a board up there and this number of cases, and we just kept track on a grease board of how many are left to get in, and it just went down and down and down as we were able to get a hold of folks. Now the interesting thing about bankruptcy clients generally is that you send them a letter, they don't always open their mail.
Really?
You're shocking people here, Dan.
Yeah, it's surprising to all of you, I know. So a lot of them, I got, even though I got flooded with phone calls to my Portage office, and then of course to the Maryville office, there was the having to actually manually call people that you just knew didn't open the letter from the court clerk. So to your point, we would email them, we would text them, we would call them, can you contact the office? We need to chat with you about something.
You know, the interesting thing about the whole surrogacy thing, and you talked about a family business, if you have a family laundromat, you can hire some people and keep it all running. But the problem for a sole practitioner is there's one very important thing a law office needs. It needs a lawyer.
He's a lawyer.
And when that lawyer is not there, then who's supervising the paralegals? Who's signing pleadings, making sure all that gets done? So that's why it's such a critical thing. If you don't have that, then you're probably violating some criminal statute on practicing law without a license. So you don't want to put your people in that position either. You've got to really think it through. Let me tell you real quick about the other situation. We've had two of these, and they affected both courts, both South Bend and Hammond. Drew Red also passed away, as I mentioned in the introductory remarks. He also had a surrogate, but his surrogate was not a bankruptcy practitioner. And so he did many of the same things that Dan did, except he did not enter appearances, even if people wanted him to, because he didn't feel competent to do that. That was not his area of expertise. So he was more into the make referral modes, which is one of the things that you can do. Is I'm your surrogate. Here's a list of 3 or 4 people, and he consulted with our office and the judges as well, both Judge Ayler and Judge Lindquist. And you know, he had a smaller practice, but it was still a decent volume. I think it was maybe 100 files in bankruptcy. So those were mostly referred out. There might have been 1 or 2 things at the conclusion where he entered his appearance and signed a motion for discharge or something that was we kind of worked through with him. So interesting change, but yeah, you really need to think about that. So the noticing was taken care of by the clerk. I assume some of the clients maybe went elsewhere. You gave them referrals. Have they found people? Did some go elsewhere?
Very, very few.
Okay.
Because from the client's perspective, Paul, that's the other part of it. So let's assume that I just wanted to refer them all out. In the client's mind, they've already paid a lawyer. So now you got to explain to 800-900 people, listen, you got to go find another lawyer, and you're probably going to have to pay him or her. That's a very difficult conversation. So when I would say, I am willing to enter my appearance on your case, I'll just see it through for you. From the client's perspective, it was a whole lot more attractive for them to stay. Now, the interesting thing, as I tell people, is that Kevin and I had kind of a gentleman's arrangement where when we would have a client that would become so terribly problematic for us, maybe the relationship had broke down, or maybe they file repeat filers and they're just not listening, or we would refer them to each other. And so there were a fair number of folks on that list that conversation that I had to have with them was, okay, remember me? So, but they stayed, interestingly enough. So, but yeah, so almost all of them stayed, just a few didn't.
I think it's probably fair to say you couldn't create a more perfect storm for this thing to have occurred in, or a perfect pandemic, or whatever you want to say. So,
Well, and I don't think we can lose sight, and certainly not to make light of what happened, but we can't lose sight of more than likely the majority of these surrogacies, when they kick in, are going to be short term. For example, a lawyer's on vacation and is skiing and breaks his or her leg, and is now out in Colorado in the hospital for 4 weeks. And if that's a solo practitioner, that surrogacy kicks in. It should kick in because there's going to be things that are going to happen in that practice over the 4 weeks that the staff cannot handle because there is no lawyer at the desk. So, and I think what we all saw as we were preparing for this time is that these rules are really set up for the general practice. It's not set up for what it is that the majority of us solo practitioners do in bankruptcy. And the good news out there, again from the ethics point of view, is the rules are really not set up to punish us. They're set up to guide us, and the surrogate reaching out to the right people, or at least for the help, whether it be the judges or the clerks and any of those involved. Very important, very good instinct to do it that way.
Yep, and I would agree with that. And it's not just an attorney passing or becoming, as you've noted, long-term ill. What the rule contemplates, if an attorney has, of course, passed away, disappeared, that's another one, become disabled, or is disbarred or suspended. So that can conjure up. I mean, the rule is designed to protect the clients, right? It's designed to get somebody in the game that can protect the clients and give that person some immunity while they're doing it, if they do it right.
Question, Jerry.
Yeah, if someone is in the middle of a 13, let's say 3 years of a 5-year plan, and the attorney has received the full no-look fee, then he becomes unable to practice, then would there be would the new attorney, the surrogate, be able to apply for the work that he actually performs the final 2 years, or would there be, no, you've already received the new, would it be bifurcated by the work that the attorney, the surrogate does for those last 2 years?
Okay, let me restate the question for those that are virtual. So a case is going on. It was a presumptive fee, kind of flat fee case. 3 years in, the fee's been paid, maybe as part of the plan. Now something happens to the attorney. What happens? The new attorney comes in. Does the fee have to be, I suppose, partly disgorged? How's the new attorney get paid?
So, again, this rule isn't really designed for bank. That's a good example of where it's not really designed for bankruptcy, because the rule says you can apply for a fee to fulfill your surrogate duties. But if you think about that, that's really about sort of winding the practice down or getting these folks referred somewhere else. So in my situation, in that situation, you could apply for fees and keep track of your time and get paid reasonable fees out of the estate of the lawyer.
And that would be probably that state court judge that appointed you, approving and allowing that, correct?
That's right. That is correct.
And it would come out of the practice funds, not out of the client.
That's correct. So, but in my situation, as I indicated earlier, I just, if the case moves along and there's no issues, or just, the kind of stuff that we normally do, talking to the client, talking them through general questions that come up, I'm not getting paid. But if something, happens in the case, like they want to sell a house, or they want to, not be dismissed for some, ne'er-do-welling that they may have been doing, I suppose I would apply for some fees for that extra stuff. But generally speaking, I'm not. Which, if I weren't, again, if I didn't have the Maryville office, Kevin's staff, and I didn't have my staff, and I wasn't already in a volume practice, I wouldn't have done it. Because I couldn't.
Any other questions on that while we're here? All right, so the formality of it, you have to name someone if you're a sole practitioner when you renew your license each fall. I think those renewals just went out, so some of you may have just done that. You implement it with a court order of competent jurisdiction. That's going to be, Superior Circuit Court in the county where the practice is. If there's no designation, if you don't have a designation or the person won't do it, then they can appoint a senior judge or some other practitioner. And for all the reasons Dan's talked about, it's probably better to have somebody that knows something about your practice that can jump in there. Special problems of bankruptcy, Dan's hit it. The rules just don't anticipate that kind of practice. The bankruptcy court is not the court of competent. It's limited jurisdiction court. That's the first thing that happens in every federal case. You got to establish you've got jurisdiction. But the bankruptcy courts do care, and Judge Ehler and Judge Lindquist were very concerned about it and what was going to happen with what was probably the biggest number of cases that any one attorney had in my office, for sure. So,
being notified, we were, I hate to say fortunate, because it was a terrible circumstance, but we had, is that better? We had been made aware of the situation, I believe, to the clerk's office, that this was ongoing, because this, with the type of practice that he had, that was a significant number of deadlines. And I mean, he was probably in my courtroom probably more than any other lawyer, with the sheer number of cases. And there were key deadlines every single week. So being prepared as a court with Judge Lindquist, we had to sit down and make a plan for that because that situation greatly impacted our schedules, and we knew the absence of that particular attorney was going to have a significant impact on our docket.
And I think both you and Judge Lindquist were very good about saying, gosh, this is one of Mr. Schmidt's, let's roll the case 30 days and hopefully he's back. I mean, we were all hoping he'd be back, obviously, and after a couple times that didn't happen, we had to come up with a different plan. Yeah, Peter. With respect to what? I'm sorry, I couldn't hear. Okay. Does it interact at all with the
interest for the surrogate to simply take over and substitute in cases that may have some value?
Okay, so is there any duty to the debtors or the attorney's estate? Do you have any duty to them specifically? I suppose you work with them in some fashion. I don't know if there is an estate in this case or not.
I don't know. I don't think there's been an estate opened up. And I guess the question would be, what are you selling? You can't sell clients. Okay. You're not selling 700, 800 client files. The surrogate has a requirement to notify those clients that they're A, pro se, and make referrals and take control of things like the trust account and the other accounts of the law practice, but that's more for the either wind down of that practice or the management of those files. The surrogacy rules I don't read to say that I have to do some marketing strategy to sell the practice by any stretch of the imagination.
If it is a situation where it's wound up, I suppose once you're done, then that money goes to whoever's designated by the attorney's estate or will or trust, or if it's a PC, wherever the stock goes under his estate planning.
Right.
Well, phone numbers and goodwill have value. In Indianapolis, several lawyers have taken over practices of deceased attorneys for value from the estate and even operate them. For instance, Mark Zuckerberg operates a practice, Walton Legal Services, under Walton's name. Walton is deceased. These law practices do have value. I've purchased bankruptcy practices for large sums of money, and law practices do get bought and sold. So the issue in a surrogacy is in preserving the practice, making sure the clients don't get hurt, and is not the best way to do that to have somebody take over the practice and pay the estate for whatever the value of the goodwill is. Phone numbers have value. I've got phone numbers people call 15 years later when they're not even in public because they're stuck.
So I can't say that the rules of surrogacy require that, Peter. I don't read it that way. But understand that in this situation, let me make a couple of things clear. All of the clients were given the option, whether they wanted me to enter my appearance or go elsewhere. I didn't just simply suck the practice up. And the arrangement that I have with my closest friend's widow, I'm not going to speak to here today. But I can assure you it was fair.
Sure. So was my question.
Yeah.
Does the surrogate have any duty to interface with the estate of the deceased lawyer for the benefit of that estate? Isn't there a conflict of interest if the surrogate does not act on behalf of the estate?
I don't think the rules of surrogacy require that, but I think as a practicality, you have to.
Sure.
Right? So I think if you're truly going to do the surrogate job to its fullest and see it to completion, you have to have a relationship with and an understanding with and a lot of conversations with the estate, whoever that may be, of the attorney who has unfortunately deceased.
Using my my Evelyn Gowalaki High School speed reading course, I've taken a look at the rule, and there is only, all I can see is one time where the lawyer's personal representative is mentioned, and it's in C2, where the surrogacy rule is set up by definitions, and then what the surrogate shall do, and then what the surrogate may do. And the notice that has to be sent by the court shall go to the lawyer's personal representative. So there is at least one time where there shall be some sort of communication, but it actually comes in that notice of the surrogacy. Right. Then you kick down into all the mays, and that's when it talks about you may wind it up, you may do this, you may do that. So I think that's the only guidance. Now, I'm not certain, because fortunately I haven't ever gone down this path to this extent, if there's any case law in the state of Indiana that provides guidance under this rule. Did you ever have to find any?
Yeah, we actually did a pretty deep dive, and again, the things I found with respect to surrogacy in Indiana just didn't, the cases just didn't apply. There were disputes, there were things going on, there were roles where cases where surrogate overstepped his or her bounds, lost their immunity, got sued, those sorts of things. But I didn't stumble on anything that really spoke to a surrogate in dispute with the estate of a deceased attorney. I did find a few where the surrogate was in a dispute with the attorney, where the attorney was either suspended or disabled under the definitions of the rule, and didn't necessarily want the surrogate doing things. So there was a plethora of that going on. But I didn't get too far into that because that's not what's happening in my situation.
All right, we've got about 3 or 4 other topics we want to touch quickly, unless anybody else has something to finish on that. We have
can I throw in one thing
ahead,
real
please,
quickly?
Judge.
There is, when you ask about some helpful literature, when this came up, I started doing some searches myself. There is a best practice form put together by the Indiana State Bar Association on surrogacy, and it's an excellent guide of trying to put some practical sense with the rules and some examples and some forms you can find. You can Google it. That's how I found it. But I would suggest, if you're saying, I don't know how any of this is going to work, I don't even know where to start other than the rule, go look at this. It's a little bit dated. The publication I have is 2010, but it's certainly helpful and does provide some case sites and pulls the rules together. So I would encourage you to go look at that. It's a great starting point.
Okay, let's move into our other areas. We've got 4 little pieces of material behind the surrogacy stuff, and we want to try to talk about as much of it as we can here in the next 12 or 13 minutes that are left. Let's move to the don't get it on paper one first, just because it's kind of the most fun and probably the one that's going to capture you. Doug, you want to lead off with this?
Yeah. It's I found this to be quite an interesting read as to old school law practice versus new school law practice, and that is, what does it mean to get something on paper? And in this particular case, it was similar to Indiana. New Jersey has the ability where lawyers can write in and ask for an advisory opinion on a thing, and what it all boiled down to, at least as I read between the lines, is there was a settlement negotiation going on, and lawyer A sent to lawyer B the settlement offer and CC by email. So we hereby offer you $500 to do whatever, and CC'd the lawyer's client, just to let the client know, apparently, I tendered your settlement offer. The question then becomes, if the recipient lawyer hits reply all, in the reply. Has the recipient lawyer violated the prohibition to directly communicate with someone that's represented by a lawyer? And the New Jersey Ethics Commission, or whatever title they have, basically said, no. If you send a hard letter, like us that have been practicing for a number of years used to send hard letters and CC your client, no one in their right mind would believe that they could copy your client with that reply. So if it was in paper, there's no consent. However, what New Jersey basically said is that emails are more informal, similar to you having your client on a phone call with you. So if I picked up the phone and I called Paul and my client's sitting next to me on the phone, Paul knows that, or it's on a conference call, and I say, hey, we'll settle for $500, and Paul says back to me, no, I really need $1,000. The client's sitting there, it's informal, it's implied that my client can hear that. So they equated emails to an informal phone call. But if it's the old-fashioned way, by letter, that's not this implied consent. So I found that fascinating because, at least in our neck of the woods, in order to save postage, and I'm sure Paul probably does it too, and we'll see, but in order to save postage, you get the following email. Please see the attached letter from the trustee. And then you hit the attachment, and there's the letter where Paul may or may not CC his client. What happens in that situation? Are we using the old or are we using the new? It scared me so much yesterday as I was rereading this that I did a test in my office just to make sure that what I had always assumed to be the case was the case. So most of you know my partner is Yvette Clevin. She's a Chapter 7 trustee in Fort Wayne. I sent her an email and blind copied our paralegal. And then I had her hit reply all just to see what happened. Thankfully, it doesn't go, the return hitting reply all simply goes to the recipient and the CC, not the blind copy. So it does kind of act like a letter, yet the New Jersey Commission says, no, it's more like a phone call.
Yeah. Just kind of a surprising opinion, and the other thing is something to be aware of in your email practice. Speaking of emails, Judge, we've got another piece of material in here about why a missed email or maybe pacer download could cost you your case.
And this relates directly to your situation, Dan. How do you manage your communication? And what am I tasked to do? And as lawyers, we're all tasked with certain rules which we have to live by. One of them is your duty to monitor the docket. And courts have held, and there's a growing body of case law, which would suggest that that duty involves or requires, not involves, requires actively monitoring your docket. Not just saying, hey, I got an email on this 2 months ago, and so nothing else is going on in the case. That's not true, and that may not be true, but that's certainly not what courts envision your duty to be. It would be to actively have someone monitoring the case, and there's a heightened sense to do that in a bankruptcy practice where we all know we have shortened deadlines compared to maybe other courts. So this envisions a case, this particular case, Rollins v. Home Depot, envisions a case where another party filed a motion for summary judgment and notice was sent through an ECF-like system to the other party, and it mistakenly went into a different email folder, and they never responded to the motion for summary judgment, and then the time runs for them to respond. There's no response. The court enters judgment, and then the other party calls up and says, let's talk about settlement. Okay, let's talk about settlement. Well, I want all of this, and I'm not going to give you anything that we were bargaining for 6 months ago. And then the question becomes, well, what's the change in the position? Well, the difference is, since we last talked 60 days ago, I now have a motion for summary judgment that's been granted. And the lawyer says, what are you talking about? I don't even know what you're talking about. You don't want to find yourself in that position. In this case, the lawyer then moved the court to set aside that judgment, trying to explain, hey, I can prove to you, like it went into a spam folder or another folder as opposed to the one that I always check and my staff always checks. And the court said, that's not good enough, denies the motion, and then it goes up to the circuit. And the circuit very clearly in this case, I think it's the Fifth Circuit, agreed with the district court and said, you have an active obligation to monitor your case, not just wait for notices to come to you. So, and that's, when you think about it, that's scary in a case where you are, Dan, where you all of a sudden become the attorney. And now you're tasked with 900 cases where you better know where those communications are, because there might be 14 days to file a response to a motion for summary judgment. So it's real clear to just wait and do nothing and say, I'll just wait to get another email and that will trigger my obligation. The courts liken it to, that's the modern day equivalent of the dog ate my homework argument. And it's not going to carry you very far. So if there's one thing to be learned from the whole thing of this scenario, is courts across the circuits have held that counsel are obligated to monitor the court's docket. And in this case, the person did not do that, and they lose, and that's the end of the story. And you find yourself then on calling the insurance carrier after that.
Well, and in my situation, I have, Judge, I have the benefit of having my wife as my law partner, and frankly, she just scares me. So that entices me to check those emails daily.
Well,
The other thing that happens in the surrogacy is you do get an opportunity to extend certain deadlines.
Right. Yes.
And again, a lot of the things we did were informal, but if you had, for instance, something that was going to be an appealed and some hard deadline, and the opposing counsel, you know, to say, I don't want to grant an extension or wouldn't agree to one, you might have some protection as a surrogate. But yeah, managing the flow of stuff from PACER and stuff is a huge challenge. I know in the trustee offices, you know, we want to get things to the right desk. We want to make sure, of course, calendars are easier to pull up. You can pull up a calendar and see for the week, where do I have to be? You know, you can pull up each judge, and if you're practicing in multiple divisions. But where are those documents going? Everybody's, I'm sure, addressed that in a different way, but just a case to highlight that.
If I may, from a practical standpoint, I would suggest that you take this one little nugget away today and rethink, or at least put a little bit of time on how you and people in your office do handle ECF and PACER. Because as I understand it, there's really two ways you can get notice. You can either get the batch notice that comes out at midnight, and you basically would probably get it the next morning of the filing. Or if your practice is not as voluminous as a numbers are, you can actually get them instantaneously. And it's interesting enough, in our partnership, Yvette has decided to do it daily because of the number of pending cases, and I do it instantaneously, and even knowing what has been filed in the last hour of all of my cases. Now, that's because of the smaller amount of volume cases that I do. But just take a look at it, because what this is telling you is the buck stops at you. And so, you know, your malpractice carrier is going to want to know that if you do it instantaneously, how do you handle those things? If you do it in the batch, what do you do in the morning to make sure that you review and print off, or whatever you do, the important things versus the BNC kind of stuff that, you know, may not be as necessary to continually monitor.
Let's finish real quick with the ethical guidance for lawyers working remotely. There's also one on secure communication. It's a little bit incorporated into this topic, but take a look at it. You should be using some sort of encrypted system. If you aren't, I'd suggest you start doing that. Documents you send to the trustee office and our portal delivery, those are all encrypted documents. But this raises two different issues if you're working remotely. One seems to be fairly easily resolved. But what if you're working remotely in an area you're not licensed? So Dan, he wants to go up to his condo in Trump Tower.
Yes.
And because he likes to view the lake when he works. Just kidding. Is he practicing in Illinois where he's not licensed? If you're just working on your files from Indiana? I think most of the guidance in here is, no, that's not really practicing in Chicago. But if he's somehow modified his website to use that as an address, maybe. If you're not advertising that location as an address and actually doing business there other than just working on your files, you're probably fine. But it is something to think about. If you say, you know, I'm up here enough, maybe I'll just see if I can pick up some Chicago cases. Well, wait a minute, am I licensed? You know, so that could apply anywhere that you might be out of your jurisdiction. The other issue in there, of course, is, as I indicated, unencrypted email is insufficient for particularly sensitive information. We all have personally identifiable information. That's a huge issue for trustees to protect that information. I've got 5,000 approximately open cases. I've also got another 25,000 closed cases. Most of those, when they're a few years old, I take off of my system and I archive them because I don't want that exposed to a hack. I don't want to expose more people than I have to, but what sort of system do you have to protect your data on the internet? Give that some thought and talk to your IT folks that either you have on staff or consult with, depending on the nature of your operation. So take a look at those things. Anything else? Final comments? I think we're up to our lunch hour. Pull your lunch coupons out. So they will come around and they'll know what lunch to give you. Deb, anything else we need to know about lunch?
Well, two things. Online attendees, there are no code words, so don't worry about that. And also, please check your email throughout the day, especially if you lose the signal again. We'll send out a new link for you. Other than that, lunch is going to be served.
For the live streamers, I think the streaming is going to stay on, right?
Right, live streaming is going to stay on.
And there are no code words, right?
And I believe we're going to resume at 12:45. Is that correct?
We'll resume at 12:45. We'll try to keep the thing, since we're a little ahead, we'll try to stay ahead and get done a little early. So, thank you.
Thank you so much.
Good to see you.
Here, so I can kind of see that. Button right here.
No, because it's not red. Okay, can everybody take their seats so we can start, please?
These lights are blinding.
Can you talk?
I think so, yeah.
Okay. So please don't fall asleep. I know it's the panel right after lunch, and I know it's not exciting to you all, but it is exciting to Jessica and I because we're actually talking about mortgages, yay, forbearances, escrows, and CFPB.
They've only described us as slightly insane.
Yeah, probably more than slightly insane. You can't? Wow. Okay, is that better? Okay, sorry, I'll be good. To my left, to your right, is Jessica Owens. She is the supervising attorney.
A supervising bankruptcy attorney for Doyle and Foudy.
And if you don't know Jessica, she's the person you want to call when you have a problem with a mortgage, especially if you're a creditor attorney and you represent banks. She can explain to you what escrow does, RESPA is, and how mortgages are supposed to be handled in a Chapter 13.
I accept emails as well.
So what we're going to talk about today is what's happening now that the moratoriums are coming to an end. As you know, there was an eviction moratorium, there was a foreclosure moratorium, there's forbearances, there's additional supplemental proof of claims that have to be filed on those forbearances. There's a whole host of deferral and escrow issues that are arising. Also, as debtors counsel, we're going to talk about what your duty is within 30 days of the time that a forbearance supplemental claim is filed. We're going to also talk about there's some changes that are coming to the bankruptcy world in the bankruptcy rules, and we're going to talk about just some other industry things. To give you some stats, because I know all of us are like, we're never going to have Chapter 13s again. CFPB actually came out with new regulations, and they're rough.
Yeah, they are. They definitely have some requirements for loss mitigation. There is some additional requirements due to servicers whenever they come out of forbearance. There's the new Rule F, which imposes a bunch of different requirements on servicers and attorneys. So it will be a little bit of a learning curve for all of us coming out of the COVID and the new requirements. But I assure you, once we all figure it out and it gets going, it's not just going to hit a little bit, it's going to probably hit very hard within the next year.
So right now what's going on is, yes, the foreclosure moratorium has been lifted, but the new CFPB guidelines actually put a number of things that servicers have to do before they can file a foreclosure. At least the servicers that I've talked to, which tend to be the really large servicers, they've decided that they're not even moving forward with looking at foreclosures and with filing foreclosures until January. And it's because of these new regs and everything else. The ones that are currently being filed, there's a few exceptions.
You're looking at the foreclosures that we began prior to COVID. So these are cases that were already in foreclosure. I know we spoke to one of the debtors' councils yesterday, and they said they're starting to see sheriff sales coming through. And that's because we are proceeding on those cases that are still delinquent and have been delinquent since prior to the COVID emergency. You also have abandoned properties. We are proceeding with those and have been this whole time, to be honest, to make sure that those houses don't go into disrepair and fall.
So I have not seen Black Knight's numbers. Black Knight is this computer giant that services and does the accounting for lots of mortgage servicers, and they keep a lot of statistics. So 1.45 million current first mortgages are seriously delinquent. Serious delinquent is 90 days or more past due. Compare that to before COVID, only 500,000 mortgages throughout the country were seriously delinquent. Currently, 4.14% of all mortgages are delinquent more than 30 days, and that doesn't include the ones that are already in foreclosure. And 2,346,000 properties are 30 days or more past due. I think and I don't think I have it, but there is a worse What was the estimate as to how many mortgages are more than a year past due?
I'm sorry, I don't remember that.
I know it was over 500,000. I mean, it was absolutely amazing. So
Now,
we've-
part of these figures also include loans that are in forbearance as considered delinquent. So as things process, we'll be seeing some of these resolved via either deferrals or loan modifications. So the number seems very large, and hopefully that can be dwindled down as debtors come back and they're starting to make money and they're starting to do remedies to handle these delinquencies.
but the homeowners currently can still file for forbearance, is that right?
That is accurate. In regards to the CARES Act, they're still able to go ahead and request those forbearances with FHA. The FHA ones have to be requested by September 30th, but there's no date for Fannie and Freddie currently on when those can be requested. So if you find you have a debtor that needs a forbearance, they can still request it, and it's still being approved with no additional documentation. They're just approving them across the board.
One of the things that we're aware of is that Washington is looking at extending some of the deadlines that are currently coming up, because there's two sets of deadlines. Some of these provisions actually ended back in March of 2021, and some were extended to March of 2022. The ones that ended back in December is the stimulus payments aren't disposable income. The debtors who have 3 or fewer mortgage payments due to COVID might still be able to get their discharge. The mortgage servicers file a supplemental POC to let us know about the mortgage payments missed in a foreclosure, and that any party, including creditors, can file a motion to modify a plan to provide for those mortgage payments that were missed. And Jessica, how many servicers have actually done that after they wanted the law changed so a servicer could come in and modify a plan?
We don't modify plans. Debtors Council, we're leaving that up to you. We will file our supplemental POCs for forbearance, for forborne payments, but as for modification of the plan, we are not doing that. We're expecting Debtors Council to go forward and do that.
And remember, under the CARES Act, as Debtors Council, once that supplemental forbearance claim is actually filed, you are required within 30 days to take some action and to modify that plan or advise the servicer how the debtor is going to pay those funds back. I can tell you I get more and more emails from Creditors Council who say, Debtors Council hasn't done anything on this. We're going to do a motion for relief. And I say, give me a second. And that's when you're seeing emails from me saying, hey guys, you were supposed to do this 2 months ago. What are you going to do? So if you have clients that were in a forbearance and that supplemental proof of claim is filed, you have to contact your client, contact the servicer, and get that resolved. Because if not, either relief's going to be granted or they may ask for the case to be dismissed. So be sure you know what your duties are on that and make sure you do what you're supposed to. The other thing that you need to be aware of is the time to extend a Chapter 13 plan, that the case had to be confirmed prior to March of this year, and you're able to take the term of that plan out to 84 months because they had a COVID issue. That's expiring March of 22. So if you have a client who's in a forbearance now or way far behind or whatever, you need to start working on that because that provision actually ends in March.
And just to note that part of that working on it is contacting either our office or the creditor directly, depending on the situation, and working with us and the creditor to figure out how those payments are going to be cured. if they're going to be doing a deferral, if they're going to be doing a loan modification. These are things that need to be done before that modification is filed. You need to be figuring out how the servicer plans on treating them as well.
Creditor attorneys, remember you are not entitled to be reimbursed for any attorney's fees when working on any sort of forbearance or COVID issue. If we see them, we will object. That is not allowed according to the CARES Act. Is there any, that's pretty much it, right?
Yeah, no, those fees are not recoverable.
So, and debtors counsel, if you see them, you should be objecting to them. Is the trustee going to be filing a motion to modify the plan if the debtor does not act within 30 days? I'm going to give you the answer that I give to my staff when it's something that I don't want to do, which is if you really want me to modify the plan because you won't, you may not like how I try to modify that plan, okay? Because you're going to extend it out to 84 months, you're going to do what you need to do. I'm not going to do that. I'm going to take it and say, okay, there's $2,000, we've got 10 months left. That mortgage payment, that monthly payment needs to go up $200 a month, and we're going to file that motion to modify. If you want something other than just a standard modification from our office, that's upon you all to actually file those modifications, not us.
And you did say you also could possibly be requesting updated financials in regards to these forbearance.
I think, and I'm looking at Cindy here, but I'm pretty sure that when we've had a forbearance asked for while they're in the middle of the 13, one of our first questions is, please send us current pay stubs and explain why the debtor can't afford to pay their ongoing mortgage payment.
Now, remember, the servicer is not currently asking for that. In regards to the CARES Act, we're just moving forward with the forbearance. But Deb might need to see those figures and see where that money's going and determine whether or not we want to keep those going to the secured creditor or end up with them going to the unsecured.
And that's the issue. If the disposable income hasn't changed, guys, and you're asking for a forbearance where that mortgage payment doesn't have to be paid for 3 or 4 years, that extra money goes to other creditors. So make sure that you're comfortable with why the forbearance is being asked for so that you don't have to worry about that money going somewhere that perhaps you or the homeowner or a debtor doesn't want it to go. We talked about attorney's fees. So, Jessica, I know that what I've been told was that unless a homeowner was actually current on their mortgage as of March of 2020, they would not be given a loan deferral. And first, would you explain what a loan deferral is? And number two, answer the question, I guess.
The deferral is basically whenever they take the past due amount minus escrow and tack it onto the end of the loan. This does not incur fees or interest, but it's basically kind of turns the loan into a balloon note, so that those amounts need to be paid either whenever the property's sold or whenever it's completely paid off. So it's basically just taking that past due amount minus escrow and tacking it onto the end. As for deferrals, it has been, what I have been seeing across the board is they have been sticking to the, if you were current when the forbearance was asked for, they will go ahead and go do a deferral. Otherwise, they've been trending more towards loan modifications.
So there's a couple of different loan modifications, but there's kind of these quick loan modifications, and then there's a real loan modification. So what does a quick loan modification do for the homeowner?
So those quick loan modifications are called streamlined loan modifications. And basically the requirements to get a streamlined modification, we don't need all the documents, but the requirements is that the payment can't be increased more than what it currently is, and it cannot be extended out more than 480 months.
So let's say they're in the 15th year of their mortgage and they have 15 years to go. This streamlined mod will actually take what they owe and stretch it out over 40 years. Isn't that nice? They get to pay an additional 25 years on that mortgage, guys. Okay? So your job as debtors counsel is you better be looking at, number one, is this good for my debtor? Number two, are they including fees? Because, oh yeah, remember, no attorney's fees because this is COVID. And number three, aren't they better just paying those payments that they missed in the forbearance through the bankruptcy so that they can keep the end term of their mortgage the same? So streamlined mods are not what you guys want to see your clients go into. But talk about what a real loan mod is and what they need for that.
So traditional loan modification, we're going to need all the documents. We're going to need pay stubs. We're going to need expenses, the normal things that you provide in a loan modification, along with a big packet. And it does take time. And that is a time when they want to make sure that they're in close contact with their point of contact representative with the servicer. But those loan modifications, they can do the same thing that a streamline can, but they can also do additional things. They can lower the interest rate. They can lower the principal balance. They can put a deferred amount in addition to the loan mod terms. So there are multiple things that they can do in a traditional loan modification that aren't really available in the streamline.
You know what the biggest thing is, though, about a regular loan mod? You know the pre-petition arrearage that your client owes when they filed that Chapter 13? When they do a regular loan mod, they take that entire pre-petition arrears that's still owed, and it's included in that loan mod. Now, there are some debtors who that's the only reason they're in their bankruptcy, that once that arrearage is cured and they're current on their mortgage, they're going to go out. And if that's what's best for the debtor, that's what you do, okay? But realize a regular loan mod always has to include the pre-petition arrearage, and then they can change the interest rate, they can change the term, they can change almost anything about that loan. So the gold standard, at least for me, is you want to get a regular loan mod. You really don't want to see these streamlined loan mods. With that being said, I don't know of anybody in this room who believes that the mortgage servicers, except for maybe Jessica, can properly apply payments, okay? So when you're looking at the numbers for the loan mod, make sure that they're not including more on the pre-petition arrearage than what they still owe. If our system shows that there's a $5,000 left on the pre-petition arrearage, and they're putting in $10,000 as the pre-petition arrearage, you need to ask questions because it's wrong.
And they should be giving you a breakdown in regards to what that pre-petition or what that pre-modification arrearage actually includes, because I mean, obviously there will be some post-petition involved in there too. So they should be giving you a breakdown, and if not, you can always ask for a breakdown of what that amount entails.
The bad thing about deferrals and loan mods is it doesn't include the taxes and insurance that have been paid out during the time that the debtor wasn't making payments. And if they were in an 18-month forbearance, that means that you have 18 months, bless you, taxes and insurance that has to be made up. That's a lot of money. And if you're in the bankruptcy, the next time that they do the escrow analysis after the loan mod or after the deferral, there is going to be this large sum of escrow shortage that's going to be due. Now, some servicers are being nice.
Right. Some servicers, if it is over what their normal threshold is for a shortage, they will go ahead and they will automatically extend it out from the normal 12-month period to a 36-month period, and I've even seen them go out as 60. Typically, whenever I see them go out to 60, it's more of a request from the debtor, but I have seen some automatically go out to that 3-year period.
One of the things you can do when someone's still in a 13, let's say they get the deferral, they get the loan mod, but they owe $3,000 in back taxes and insurance. There's no reason that you can't file a supplemental claim in the bankruptcy, modify your plan, and pay those so that when your client walks out, they have the fresh start without that hanging over their head. There will be debtors that when we do the notice of final cure and the motion for determination that are going to have negative escrow amounts due. If they have taken the $2,000 and they've spread it over for 5 years and you're only 1 year into it, you are going to have some negative escrow when that debtor gets out of the bankruptcy. So just be aware of that. Our office, of course, looks at it and does the calculations, but you know, sometimes that happens because of these forbearances, deferrals, and loan mods.
And it could also happen just based on when we do when the notice of final cure is filed. There have definitely been times when it's been filed right after my client has dispersed for taxes and insurance and everything's went up crazy, and it does occasionally happen where it's negative that way as well.
Oops. One other thing, I mean, I don't know about you all, but when I got my property tax assessment this year, I was kind of shocked because it's amazing how much they think my house is worth. Realize with those additional, with the higher assessments in northern Indiana, we're going to have escrow shortages anyway, even in a normal mortgage in the next year. I know that my property taxes went up 38%. Well, okay, if they're going up 38%, then we have to catch up what it was last year and what it's going to be next year. And so there's going to be quite large escrow shortages coming even without the forbearances, the deferrals, and the loan mods.
Yeah, I've had to file an appeal on my property taxes the last 3 years. I'm like, stop doing this.
There was housing assistance through the CARES Act. From what I understand, it's gone.
Yeah, those monies are gone.
There was rental assistance through the CARES Act. It's for both the landlords and for the renters. Last thing I heard, there wasn't much left.
I really don't know. I don't do a lot of rental assistance, but that does not surprise me at all. A lot of those funds are going very quickly because we're obviously in a pandemic, and if people can get those funds, they're definitely going after them. So that does not surprise me.
One other thing, and I didn't know this, so someone added it. If you know someone who passed away from COVID, there actually is a provision that you can get assistance for the funeral. So if you have a debtor who lost a spouse or someone close to them, they can get up to $9,000 for the funeral expenses. Just a couple of quick things on the federal bankruptcy rules. Those of you who follow 3002.1, which probably isn't many of us, we have a new local rule this year. And what happens is when our office does a notice of final cure, or when Paul's office does a notice of final cure, there's actually a form that the servicer is required to fill out. It gives the unpaid principal balance of the loan. It gives the escrow balance, the suspense balance, and next payment due.
It requires a payoff to be attached.
Yeah. And the reason that the reason that a payoff is required is, remember, there's the two systems we've talked about. where they apply the bankruptcy payments in this system, and this is the contractual system. And what we want to make sure is at the end of the bankruptcy that they match. And the only way that we can do that is to get a payoff. So that's why that's required. I can tell you that I know for a while we were able to close our cases about 45 to 60 days quicker once that rule was implemented, because the servicer were giving us the information we needed, and it was all better.
You're welcome.
I know. It's fallen off now, but at the beginning, it really did work. But that is actually a new change that you're going to see. It's out for comment right now with the federal bankruptcy rules, that will actually go throughout the country. The other thing that you just need to be aware of is if you ever have a debtor who is paying the mortgage outside the trustee conduit, sometimes they get behind, nobody knows, they get to the end of the bankruptcy, and I'm pretty sure in all of our courts, if you haven't made your mortgage payments in a Chapter 13 direct, you get dismissed. You don't get your discharge. There's a new rule that's going to go into place about 2 years from now, that about 2 years into the bankruptcy, the trustees will actually be filing a notice, and it's going to require the servicer to tell us, the court, and you as debtors counsel, whether or not your debtor is making those payments direct. And I can tell you that when we find out that a debtor has not been making their mortgage payments direct, the first thing that we do is do a motion to dismiss. And I would think that that's probably what's going to happen with most trustees who are conduit, that if once we get these notices back saying that they're not current and they've missed payments.
Would a proactive debtors counsel maybe file a motion to modify at that point?
That would probably be a smart thing, and maybe bring the mortgage payments inside.
Yeah.
But do realize that that's coming. So we have actually seen, not so much for us because the servicers will contact us, but there have been cases where the mortgage isn't paid for the full 36 months of the bankruptcy, and then they want their discharge. This rule is actually to stop that.
I would note that if motions to modify are filed and it's because the debtor is delinquent, to put the specific amounts or specific dates that the trustee would need to pay. Don't make us guess and assume. I'm not good at that.
So, Jessica, what do you see as the biggest issue facing debtors in Chapter 13 in the next 6 months?
In
12 months?
the next 6 months, I mean, for creditors and for debtors, the biggest issues are going to be these loans that are coming out of forbearance, these loans that are being modified because of forbearances. I feel like the biggest issue is making sure that those motions to modify the Chapter 13 plan are filed timely, that everybody knows how those forborne payments are going to be cured, that there's no question of, oh, well, can they pay all of this in 60 months? Probably not. You're probably going to need to be extending that plan out 84 months. And remember, there's a sunset for that. So in the next few months, you're going to want to talk to your clients, make sure if they are in a forbearance, how those are going to be handled and what steps need to be taken to get those cured. Same with servicers. Whenever those loan modifications and those deferrals are coming through, we need to make sure that we're amending those proof of claims to adequately reflect if the pre-petition is being capitalized. We need to make sure that we are filing the motions to approve the loan modifications. Those things are going to be our biggest issues that are going to be arising, just because the forbearance obviously was a really new thing for us in regards to bankruptcy at this level. So it's definitely going to be a new thing whenever they're all coming out of it.
And I have one last question. What do you think we're all going to be doing in June, July, and August of 2022?
Crying at our desk, wondering what happened to all that free time we had in our lives and where it went.
Yeah, remember if they start filing foreclosures in January, they've got 30 days to reply. They could possibly go for mediation, but it takes how long to get a sheriff's sale set about?
It takes from the time we file until the sheriff's sale, about 6 months, maybe 6 to 9 months before we get those sheriff sales. And let's face it, debtors come and see you whenever it's the last moment before that gavel's going to hit. And what can you do? Can you file this tomorrow? I have a sheriff's sale tomorrow.
So I wouldn't take any big trips in June and July, was just my suggestion. Thank you so much, and we'll have the next panel coming up.
I don't want to sit on the crack.
I'm just going to turn this off.
I'm sorry? He was planning on being back, but he had to have a conference call with... Well, why don't you put it right here in the middle? And we'll pretend he's here. He's with us in spirit, I have no doubt. And that way he has the bad spot with...
I'd like to present our next panel. As you know, Judge Grant is the Chief Judge of the Northern District of Indiana. He also is the county judge at Lafayette, I guess I got that right, in Fort Wayne. Far over is Larry Greer. He is the law clerk for Judge Singleton. Angie Marshall, who is the law clerk for Judge Grant, and Robert Davidson, who is the law clerk for Judge Ayler. And this is case law.
Thank you very much. Good afternoon. I have to start my remarks, as I always do, with my standard disclaimer. Anything I say is my opinion, my view, my analysis, should not be attributed to the court or any of the judges. Use at your own risk. Since the recession 2008-2009, new bankruptcy filings have generally been in decline. Monthly filings here in the Northern District went from a high of 2,303 in March of 2010 to 474 in July of 2021. That's a drop of nearly 80%. This give you some hard numbers to confirm your gut feeling as to how business has been lately. For the past 18 months or so, the country's been operating under varying constraints due to the COVID-19 pandemic. The pandemic has broadly affected all parts of the economy. The service industry has been hit with layoffs, business closings. Supply chain for all kinds of products has been hit and disrupted. Well, it's not the complete story. I think the general economic slowdown in business and commercial activity under the pandemic is at least partially the result or a driver for the direction filings have been taken nationally and here in Northern Indiana. The written materials for the seminar have some information about case filings over a recent 12-month survey period. During this period, 11% of all cases filed nationally were from the 3 states within the 7th Circuit. Of the 7 districts within the 7th Circuit, 12% of the cases filed were from Northern Indiana. Of all the cases filed nationally, about 1% came from Northern Indiana. Consumer filings continue to predominate news case filings nationally in the 7th Circuit and in this district. The proportion of new incoming consumer cases in this district are a couple of percentage points higher than what we see in the circuit or national level. Across the board, Chapter 7 filings account for nearly 3/4 of all new cases. As 78% of new cases filed in this district, Chapter 7 filings represent a slightly higher proportion of new cases than nationally and at the circuit. Both nationally and circuit level, Chapter 13 cases run about a quarter. Within our district, the breakdown of composition of cases amongst the various divisions has varied. While nationally, about 73% of new cases are Chapter 7, the proportion here among our 4 divisions ranged from 59 to 89%. Fort Wayne, South Bend, and Lafayette are all in the high end, mid to high 80s. Hammond, on the other end, is just under 60% Chapter 7. On the flip side, nearly 41% of filings are the norm in Hammond. In our other 3 divisions, no more than 13% of filings have been under Chapter 13. This is a trend that's been true in the district for many, many years. I'll leave it to you to try and scratch your heads and figure out how come. Among our 4 divisions, the new case filings in Hammond have dropped at nearly double the rate or more than the drop in the other 3 divisions. Well, there's lots of reasons that contribute to this. I suspect job loss and smaller paychecks due to COVID that it hit the ability to make regular payments under Chapter 13 might be a factor. To borrow the stock market proverb, past bankruptcy case filings are not a guarantee of future filing activity. Our current economic conditions don't fit well with conditions that we've seen in the past. There are some economists that have suggested the end of the mortgage foreclosure moratorium and the high level of student debt will be a drag in future economic growth. Sure, I'm sorry. Okay. As I was saying, because of the hit so many people have taken, so many businesses have taken, they may be looking for a bankruptcy option to deal with their financial situation going forward. On the other hand, I've seen several reports that say there is an extremely high level of home equity these days because of an increase across the board in home prices. The suggestion is that if people are struggling financially because of an increase in home equity, that might be more of an incentive for them to look for some kind of workout rather than opting into bankruptcy. Changing gears here a little bit, as you may or may not know, beginning in February of this year, the court began assigning new cases out of Porter County to the judge resident in the South Bend Division. Since February of this year, about 22% of all new cases in the South Bend Division have been from Porter County. Given the court's overall positive experience with remote hearings while operating under COVID limitations, the court in South Bend is exploring the possibility of using video for some non-evidentiary hearings. I emphasize here that some and non-evidentiary. The court does not have a timeline right now for taking any action in this area. Any steps will be communicated via our court website. And that's the long and the short of my numbers program.
Thank you, Larry. And now for a very, hopefully, quick rules update. Although you've kind of been peppered with rules updates throughout the day. We had 2 local rules that changed in the last year. In the last panel, Ms. Miller talked about the new 3002.1-1 with responses to notices of final cure and the form that the trustee's office is sending out to the mortgage servicers to gain information to assist with finalizing and finishing up the cases. The other local rule change dealt with unclaimed funds and payment of unclaimed funds, and kind of some interesting background to why that rule changed and why we have a new local form if you're seeking payment of unclaimed funds. Somehow somebody was doing some sort of study, and bankruptcy courts nationwide are holding over $400 million in unclaimed funds, which to me, it just astounds me that there's that much money sitting in bankruptcy courts. So a task force was formed in Washington, I think around 2017, to say we need to kind of come up with a standardized, easier way for people to go get that money so that we're not holding all of this money in bankruptcy courts. And came up with a director's form to help simplify things. At the same time, there's the competing interest of making sure that the people who get the money are the ones who should be getting that money, and not, you know, hey, I'm just going to go search out bankruptcy courts and just see what I can get. So we took that director's form, which we were supposed to do, because the director's form even specifically said to be modified by individual courts. And if you were to pull up that form now, it says, I think, sample to be modified by courts. So we did, keeping it with our current local rule on unclaimed funds. So that same information, if you are the claimant seeking the money, to demonstrate your entitlement to the money is the same. The only real substantive change to the rule is adopting this local form, which is a very streamlined version of the director's form. That's the big change there. On a national level, we do have 3 rule changes going into effect in a couple months on December 1st. The first panel this morning talked about a little bit about 3007 and objections to claims. That yes, when it comes to a bank, objections to claims are, the bank is entitled to that heightened service requirement of certified mail, attention the highest ranking officer, president, CEO, whatever the bank, and that rule change is just to say insofar as objections to claim are concerned, credit unions aren't banks. That's the big one. The other change that I want to mention that's going into effect in December is for the big filers who receive lots and lots and lots of court notices. Washington, not us locally, are going to be looking at those, and if you are someone who is receiving more than 100 court notices per month, you're going to be directed to find some way to receive those notices electronically, email or some other system, as opposed to getting those notices in the mail. Again, that's not going to be policed locally. That's all going to come out of Washington. If you are one of those parties, Washington will be contacting you and saying you need to set up a procedure, you're going to have this window of time to do it, and working with you on getting that mechanism established. A couple of rules I just want to mention for next year. There are a bunch, but keeping in the theme of service, since that seems to be kind of a theme today. 7004, with that heightened service requirement, I believe the first panel also mentioned this morning, that currently it says officer of the institution. That rule change is going to say you can do it by title and not name. Just as a practice pointer, the rule will also say if you put the name and not the title, and the name's wrong, service is bad. So personally, I would just put title myself. And if you are practicing in Fort Wayne or Lafayette, that's actually the current practice right now, is if you address it to highest ranking officer, you're good, and you don't need to have the name of that CEO or president or whatever at the bank. The other change I want to mention for next year, just to kind of keep an eye out for what's on the horizon, when it comes to late claims, we know that there is an allowance for, potential allowance for late claims if that creditor wasn't scheduled. That's going to change a little bit. Instead of not being scheduled, that there wasn't a reasonable notice under the circumstances to give that creditor time to file, to be able to timely file a claim. And that change is really just kind of bringing that allowance for late claims into line with foreign creditors. So foreign and domestic creditors essentially are going to be the same under the rule. You do have in your materials the rules that are currently out for public comment. That comment period runs through next February. There are a lot of rules out there for comment, including the second batch of the restyling of the rules. Ms. Miller mentioned the 3002.1 changes to the mid-case status of mortgages. That's, I think, an important one to take a look at because I think that is going to be a big change. And the other big one is, our continuing lessons from COVID, like everything else, kind of caught unawares on how to deal with things. There are going to be rules of emergency provisions to deal with if something like this happens and the people in Washington declare a rules emergency to enable courts to extend or toll time periods and deadlines. And with that, the opening act is now over, and we'll turn it over to the main event. Judge?
Okay. As is my habit, I am going to talk about what the Seventh Circuit and the Supreme Court have done in the recent past that might have an impact on our practices. Unlike what I have done in past years, I'm not limiting myself to the last 12 months or the decisions that have come down since we last gathered. And so I'm going to touch on a couple of things that I did talk about last year, but the reason for that is I find it fascinating how a single set of circumstances in a very particular locale has consumed an inordinate amount of judicial time, litigation time, and that's in the city of Chicago. And their ravenous appetite for money and their decision to try to generate that revenue through automated traffic fines, parking tickets, red light cameras, you name it. That set of circumstances has been the subject of one Supreme Court decision, at least 5 decisions from the Seventh Circuit Court of Appeals, and we're not done yet because there will be more to follow. There are at least 2 things hanging fire. And it's really interesting because we're talking big bucks here. What the city of Chicago does is it automatically imposes parking fines, red light tickets, maybe automated speeding tickets. I don't know. I try to avoid Chicago like the plague. And it imposes these fines on the owner of the vehicle, not the driver. Not surprising because we don't know who's driving this car. It could be my brother-in-law. It could be a rental car. It could have been stolen. These fines, at least in 2016, the revenue generated from these fines constituted 7% of the city's entire budget. If you don't pay the fine, they can add up. It can result in your vehicle being booted, seized, and eventually sold. Since 2011, the city has seized and sold, not just seized and sold over 50,000 cars. This makes it one of the largest used car dealers in the nation. The issue went to the Supreme Court because the only way individuals who've had their cars impounded can get out from under, can get their vehicle back is to file Chapter 13. They can't afford to pay the fines because the terms of payment are too onerous. And you may remember that in the Seventh Circuit we used to have we did have Thompson versus GMAC. And that was the decision that held that simply retaining possession of property of the bankruptcy estate without more was a violation of Section 363A3, which prohibits an entity from exercising control over property of the estate, and not giving it back upon request was an exercise of control. And so the creditor would have to automatically return the property and then file a motion for relief from stay or adequate protection as opposed to, going the other way around. Well, that's the issue that went up to the Supreme Court in City of Chicago versus Fulton. What does 363A3 prohibit? And does it simply a retention of property without more violate the prohibition against exercising control? And the Supreme Court, kind of in a unanimous decision, although there was a concurrence, concluded that simply retaining possession of property without more does not violate 363A3. Rather, the statute, the automatic stay contemplated an affirmative act to actually do something, and just passively maintaining the status quo under which the creditor was in possession of property did not violate the stay. Now, the court went to great pains to emphasize, and this is largely the reason for Sotomayor's concurrence, that its decision was narrow. It was only talking about 363A3. And there are other portions of Section 363, for example, A4 and A6, that may be implicated by this retention of possession, and we're not going to talk about them. A4 prohibits actions to create, perfect, or enforce a lien. A6 prohibits actions to collect, assess, or recover a claim. And 542A, turnover provisions that impose a duty upon an entity in possession, custody, or control of property to deliver that property to the trustee. That may also be implicated, but they didn't talk about it. And so, when they remanded it back to the Seventh Circuit, and this is one of the things that's still hanging fire, and we may get a talk about it next year or 2 years from now, or depending on how long it takes to wend through the system. I'm sorry?
On adversary proceedings to recover.
Oh. Okay. Fan mail from a flounder. No. It remanded to the bankruptcy court to consider whether other provisions of Section 362 beyond A3 would implicate or prohibit the creditor's conduct. And so it went back down the ladder, and it'll come back up the ladder, and we'll figure it out. The second case, or the second batch of cases that I want to talk about, all involve confirmation of a plan. There are two of them, Stennis and Cherry. One of the things that the court in Chicago had done in order to maximize the protection of these motor vehicles is their form confirmation order delayed vesting. Property of the estate will remain vested in the estate until dismissal, discharge, etc. And what that had the effect of doing was protecting the motor vehicles from not just pre-petition action, because anything's protected from pre-petition action, but also post-petition action, because it's not surprising that the same debtors that racked up lots of parking tickets and speeding tickets under this automated system did not immediately improve their driving habits upon filing for relief under Chapter 13. They continued to rack up these fines and took the position that we don't have to pay because our confirmed plans don't provide for the payment of post-petition traffic fines, and you can't come and get us because the owner of the vehicle is liable. I'm the debtor. The owner is the estate. And you can't seize the vehicle because the automatic stay prohibits any action to exert control over property of the bankruptcy estate, and it's still property of the estate. So, City of Chicago, stick it in your ear. That argument prevailed, at the bankruptcy court level. Of course, it's the bankruptcy court that made the conscious decision to include the non-vesting language, shall we say, in their confirmation order. But it did not sit well with the Seventh Circuit. As they said, immunity from traffic laws for the duration of a Chapter 13 does not seem to us as a plausible outcome contemplated by the Bankruptcy Code. What they did is they looked at 1327, the language of 1327 that says, unless the plan or provides otherwise or the court orders otherwise, property of the estate vests in the debtor upon confirmation. And the court was ordering otherwise. That was the retention. This provision of the code is kind of like a default rule of interpretation, in my opinion. If you remember the provisions of the Uniform Commercial Code, if the parties don't address this, that, or the other thing, these are gap filler provisions. This is probably what they would have done. This, I think, was intended as a gap filler provision, so that if nothing is said, property vests. But if something is said, that's what will happen. The Seventh Circuit didn't read this provision that way. To the contrary, they read it as a statutory presumption, an evidentiary presumption, if you will, and in effect read it as unless the court for cause orders otherwise. They inserted that concept of for cause and concluded that the court needs a good case-specific reason to retain property in the bankruptcy estate post-confirmation, and departing from that is not the default rule, but requires effectively good cause. I think that's wrong, not that my opinion matters much, I've got to live with what they say, but compare 349, which is the consequences of dismissal. Unless the court orders otherwise for cause, dismissal is without prejudice. Where Congress wanted a for cause requirement to be built into an outcome, they said so. They didn't say so in 1327. The circuit, however, interpreted those statutory provisions as including such a requirement, and again, an evidentiary presumption. Okay, so the judges in Chicago changed their ways. We understand, circuit, we got to follow your lead. And they changed their form confirmation order to delete the vesting language or the non-vesting language. But what they also did was they changed their form plan so that it now has a box, not unlike the national form plan. Property of the bankruptcy estate will vest in the debtor upon confirmation or in the debtor upon conversion or dismissal. Essentially, they got to the same place, continuing to protect the property of the estate, the motor vehicle, from this post-petition enforcement of traffic fines. The city of Chicago continued to be upset. And the court got to revisit the issue of the propriety of this new form in matter of Cherry. Interestingly enough, the same panel that did Stennis got to do Cherry. So you're not really going to be writing on a clean slate here. And lo and behold, surprise, 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 or no surprise at all, in Cherry, the court said substantially the same thing that it said in Stennis. If you are going to, given what we said about 327, if you are going to depart from the statutory norm, the presumptive vests in the debtor upon confirmation, you've got to have a good case-specific reason. Now, once again, the court, I think, is misreading the code. I think they did the entire Cherry decision without once citing 1322A9, which talks about what a plan can do. And one of the things that a plan can do is it may provide for the vesting of property of the estate on confirmation or at a later time. It doesn't say for cause at a later time. But nonetheless, the court held that those same presumptions applied, and absent a case-specific reason, neither the plan, a la Cherry, nor the order of confirmation, a la Stennis, can do anything other than vest property of the bankruptcy estate in the debtor upon confirmation. You'd think we might be done, but no. There's a sequel to Stennis. Because remember, the city wanted its money. It didn't want to have to pay $50 or $75 to file a motion for relief from stay every time to chase these vehicles. And the circuit actually kind of thought that was a little unfair. You know, you shouldn't make them come in every time. So one of the things that they had done in Steens was file a motion for an administrative expense for the unpaid fines. And not surprisingly, the bankruptcy court and the district court denied the motion, because what do these fines have to do with the bankruptcy estate? And they're not necessary, they're not beneficial. Come on, we shouldn't have to be paying for it, and the plan doesn't say so. Seventh Circuit came to a completely different conclusion, and they analogized debtor's operation of a motor vehicle to Chapter 11 operations that, or DIP operations under Chapter 11 that resulted in tort claims. Years ago, many years ago under the Act, the Supreme Court had been confronted with a case asking the question, what is the status of a post-petition tort claim arising out of the ordinary operation of a Chapter 11 business? The injured party, understandably, wanted the highest priority possible, an administrative claim. The estate and the creditors wanted, no, there's nothing beneficial about this tort claim. It didn't help creditors, it didn't help the estate. It should be treated just as a general unsecured claim. We'll pay it, but pennies on the dollar. The Supreme Court said no. No. This is a claim that arises out of the ordinary operations of your business, and just like any other ordinary operation of the Chapter 11 business, it needs to be paid as an administrative expense. The circuit in Stennis made that same analogy to the operation of the debtor's motor vehicle. They did not ask whether the fines are beneficial to the estate or whether the fines are necessary from the estate. Rather, they said these things are no different from any other motor vehicle expense, whether it's fuel or repairs or parking. They said the question is whether operating the vehicle was necessary for the debtor to earn money needed to perform the Chapter 13 plan. If the answer is yes, and the debtors insist that cars are essential, then the cost of operating that necessary asset are themselves necessary. So since the operation of the vehicle was necessary to the production of income, the fines associated with the operation of the vehicle, which, remember, are imposed upon the owner of the car, which under the circuit's interpretation, even though they had now vacated the order, making the estate the owner, they regarded the estate as the owner of the vehicle. Well, that settles a lot of the issues in Chapter 13, but it's not over yet. There is more to come, because the bankruptcy court has issued 2 decisions, both of which have been affirmed by the district court, in Chapter 7s, in which they came to the conclusion that the process, the administrative process that the city of Chicago has put into place to get the lien and get the authority to boot the vehicle and seize the vehicle and sell the vehicle constitutes a judicial lien on the vehicle. And so, a la 722F, Chapter 7 debtors can avoid the pre-petition lien. Actually, probably Chapter 13 debtors could do it too. Can avoid the pre-petition lien on the motor vehicle to the extent it impairs a claimed exemption. The Seventh Circuit has been asked to review that decision, and last I checked, which was yesterday, the day before, the issue was fully briefed in late August in both cases. And I'm not aware, I didn't notice a date for oral arguments, but presumably next year we will have more to say about traffic fines in the city of Chicago and how they implicate our bankruptcy practice. I can also talk about some more mundane things. We'll also talk about some more mundane things because they are good practice pointers or kind of some interesting things. In Panzier, the circuit got to consider whether the deadline to file an appeal from a bankruptcy court decision, that 14-day window that you've all got when you think we've made a mistake, is jurisdictional, yes or no. The reason that they had to consider the issue is the United States taxing authority had taken an appeal from a bankruptcy court decision that it didn't like, went up to the district court, or maybe it was the debtor that took the appeal. And the United States did not argue to the district court that the appeal was untimely, addressed it on the merits, didn't raise the issue until they got to the Seventh Circuit. And if you remember, most arguments that are not raised in the court below are considered waived, except when it comes to subject matter jurisdiction, which can be raised at any time, even after judgment. So the court, as an initial matter, had to confront the question of whether that 14-day time to appeal is jurisdictional. It had previously talked about that in Sabazic, where it had held it was jurisdictional, and not surprisingly, it reaffirmed that conclusion. What I find interesting, however, two things. About a month before the Seventh Circuit issued its decision in Panzier, the Sixth Circuit in Tenniel came to 180 degrees the opposite conclusion. They concluded that that 14-day window is not jurisdictional. It's just kind of a claims processing deadline. But if you raise the issue, we've got to enforce it. Somebody's got to tell us about it, as opposed to find out about it on our own, or potentially waivable. What's kind of even more interesting is 2 years ago, the Seventh Circuit considered a similar issue in Wade with regard to direct appeals to the circuit. If you remember, you can take in a direct appeal to the circuit, which, by the way, one of the Cherry case on checking the boxes on Chapter 13 plans was a direct appeal to the circuit, which they usually screw it up. I don't know why Chicago keeps letting people take direct appeals. In any event, if you remember the way direct appeals work, you've got to file your notice of appeal, and then you've got to basically say, "Mother, may I?" You've got to get permission. And that motion to proceed has got to be filed within 14 days. And in the Wade case, that hadn't been done. And so they had to confront the issue of, is this jurisdictional? Is this something else? And the court considered that the need for that permission was not jurisdictional. It's kind of a claims processing deadline. But if you bring it to our attention, it's mandatory and it must be enforced, which is essentially the same rationale and the same conclusion that the Sixth Circuit said in Tenniel, all based upon the proposition that those deadlines are not in the statute, they're in the bankruptcy rules, and deadlines like that in the rules are merely are not jurisdictional. It's only deadlines clearly established by Congress that are. So a word to the wise when it comes to appeals. Pay attention to the deadlines, pay attention to your opponent's compliance with the deadlines, and make certain that nothing gets missed. What can you appeal is always a fascinating issue, because we have all kinds of little disputes swirling around in bankruptcy court and disputes within disputes. And that came to the court in a student loan fight involving the University of Wisconsin in Hazleton. The debtor had filed an adversary, a motion for contempt, complaining that the University of Wisconsin had violated the discharge injunction and was looking for sanctions. The bankruptcy court decided this is a student loan, there was no violation, and therefore no sanctions. Debtor appealed to the district court, who came to a different conclusion. This is not a student loan. The discharge injunction was violated, and remanded the case back to the bankruptcy court to consider the imposition of an appropriate sanction. Debtor appeals to the circuit, who says, wait a minute. This is not a final order. We only have jurisdiction in bankruptcy cases over final orders and judgment. And a final order must resolve the entire dispute between the parties, not just a discrete issue within a larger dispute. And the issue of whether the loan or the loans were dischargeable, yes or no, was a discrete issue within a larger dispute as to whether sanctions should be imposed, and a final decision wouldn't be forthcoming until that decision on sanctions, yea or nay, had been made. A good analogy to things we may deal with every time, issues which involve the valuation of property. We determine that property, whether it's a car or a house or something else, is X. But that was step one on the way to something else. Confirmation of a plan, lien avoidance, whatever, you name it. You can't appeal the decision of value until, even though you think we may be wrong, until there is a final resolution of the dispute culminating in confirmation of the plan or that final order saying, okay, the lien is avoided. So, does what you want to complain about resolve an issue within a larger dispute or the entire dispute? Or has the entire dispute been resolved? And unless and until it has been, you're not going to have jurisdiction at the Court of Appeals level. Jurisdiction can be a little fuzzier with the district court. It's a little flexible about interlocutory orders, and what they'll do with it, I have no idea. I got to put this case in the I really feel sorry for the debtor category. It's Bullock. Came out of Illinois. The debtor did not disclose workman's compensation claim. Got a plan confirmed. When am I supposed to bring this to a conclusion, by the way?
I think we have till 2:30.
Okay. Got a substantial award. A little under $100,000, I think. Of course, they spent the money, didn't tell the trustee. Trustee found out about it, objected to claimed exemptions. And this is where I really get confused on the procedure. They filed a motion with the bankruptcy court asking the bankruptcy court to compel the debtor to file an amended plan, which the court granted upon pain of dismissal. And so they said, okay, debtor, file an amended plan or we're going to dismiss the case. You might as well have said, debtor, dig your own grave. Why they went through this procedure, I have no idea, because a trustee has independent standing to file their own motion to modify the plan. Why didn't the trustee just do it? Well, the debtor dutifully complied. The debtor dutifully complied, filed the plan, which got confirmed, calling for a $15,000 payment towards the end of the plan, which would have fully paid everybody. And of course, not surprisingly, it ended up defaulting. Case was dismissed, and the debtor now appeals. Tries to appeal the initial order requiring them to file the amended plan, but the circuit came to the conclusion that it was too late to do that. The deadline for filing that appeal passed long ago. You had your choice of posting a supersedes bond, which they couldn't afford, or you could have objected to confirmation of the plan that you yourself were required to propose. And because you didn't, that plan went into effect, and the confirmation of that plan without an appeal mooted the issue of whether or not you should have been required to perform it or file it in the first place, as did the fact that the overall case was dismissed. So it became moot on two different propositions, both of them surrounding the fact that, debtor, you shouldn't have waited so long. Well, you shouldn't have waited so long to disclose the assets, but that is a different story. We say lots about local rules, and local rules often have very specific requirements. One of them, and it's common with the district court as well, is what we expect the parties to do in response to a motion for summary judgment. Somebody files a motion for summary judgment, this is how you respond. Here's your statement of material facts, here's your statement of genuine issues. It's supposed to be point by point, refutation, basic facts, no argument, cite to chapter and verse in the evidence, and if you don't file that, your courts are generally authorized to regard the undisputed facts in the statement of material facts as being unchallenged and can decide the motion for summary judgment on that basis. Well, in Hinterberger versus Indianapolis, it's not a bankruptcy case, just basic civil litigation, but it does deal with rules that we share in common. The court said this case begins and ends with the recognition that district courts may require strict compliance with their local rules. Courts expect the parties to know and follow the rules of practice, and failing to do so can be fatal. The district court did not abuse its discretion in striking the plaintiff's statement of genuine issues in opposition to a motion for summary judgment, and having done so, did not err in granting summary judgment. This is what the court characterized the statement in question as. Hinterberger's statement, as the court put it, had all the appearance of diligence and competence without a crumb of their substance. The court found that the statement failed to respond to the city's account of the material facts and instead presented a version of the events replete with impermissible argument, unsupported by citations to record evidence. The statement, the court concluded, altogether failed to identify the potentially determinative facts that Hinterberger contended required resolution at trial. Put simply, this was not lawyering in good faith, it is lawyering by confusion, equivocation, and obfuscation. It is anti-lawyering. Good advice, because one of the things I think we should all remember is the hallmark of a good lawyer is to simplify the complex, not complicate the simple. Finally, I want to talk about two more little things. One, we're not going to because we're dealing here with lawyers. We're probably not going to see a lot of it because you guys realize that when you file something, you've got to sign it. Remember, Rule 11 requires every document to be signed, not just by the lawyer, but, well, by the lawyer if the party's represented, but even pro ses are required to sign. And the rule requires that an offending or an unsigned filing be stricken if it is not signed after it's brought to the attention of the litigant, which is what happened in McCure versus Lynn. Pro se litigant didn't sign their response to a 12b6 motion. Court brought it to their attention, didn't fix the problem, and so then it proceeded to grant the motion to dismiss for failure to state a claim. The pro se appealed, and I think at this point in time they ended up getting counsel, or actually the circuit appointed counsel, which did two things. The first is unsurprising, which is it strictly enforced the language of the rule. One of the things that the litigant, the defaulting litigant, had argued was, wait a minute, nobody was hurt. Everything I wanted to say was there in that document. If I just put my name on it, you would have accepted it, and they would have known what I was talking about. You would have known what I was talking about. You ought to look at whether or not somebody was prejudiced by my failure to act. Court didn't buy that. They're not required, the circuit said, to conduct an inquiry into whether the opposing party was prejudiced by the failure to sign the document. When a party fails to correct the omission, the court is required to strike it. No discretion. But it didn't end there. Because remember, the district court did two things. One, it struck the document. Two, it granted a 12b6 motion because it regarded the motion as having been unopposed. The court said, that's not right. You still have to determine that 12b6 motion had validity. You can't grant the motion simply because it's unopposed. You've got to make the further inquiry and determination that the pleading in question fails to state a claim for relief. Now, the reason I like this is it reinforces and is similar to what the circuit has said about other things, motions for summary judgment. Remember, you're supposed to create and identify a genuine issue of material fact. The court cannot grant a motion for summary judgment just because it's unopposed. Instead, in the language of the circuit, the court must make the further finding that there are no genuine issues of material fact and the moving party is entitled to judgment as a matter of law. Now, the first component is probably pretty easy if you've got a statement of material facts that is uncontested. Okay, these are the unopposed facts. The second, maybe not so much. Similarly, default judgments. Just because the defendant fails to answer a complaint does not mean the plaintiff wins. Instead, the court is to examine the well-pleaded allegations of fact in the complaint and can only grant a motion for default judgment if it determines that those facts, taken as true, they're deemed admitted by the failure to answer, demonstrate a right to relief. Sometimes they do, sometimes they don't. We see a lot of things that cross my desk in which we believe everything the movement or the plaintiff says, and it still doesn't add up to you're entitled to win. We need more. The last thing I want to talk about is COVID-related. I don't know about you. I'm tired of COVID. I'm tired of COVID being the universal excuse for poor service, whether it's the fact that my garbage men will not pick up sticks because they don't want to touch them for fear of being contaminated, or anything else. COVID excuses often don't go over well with the Seventh Circuit either. We have a pro se debtor whose case was dismissed, district court case dismissed, because she assumed, without ever checking the docket, that because of COVID, the court was closed and no deadlines were imposed. And she never looked, she never monitored, and again, the case was dismissed because of a missed deadline. And as the circuit held, the district court was not required to treat the pandemic as an automatic excuse for missed deadlines. Like all litigants, even pro se debtors are responsible for monitoring the status of their cases by periodically checking the court's docket. And being distressed because of COVID and assuming that the court was not open did not excuse the failure to prosecute the appeal. So having said that, I think Bob may have a few words.
Yes. Can everyone hear me? We good?
I can hear you fine.
Okay, good. The first section I do are just local rule reminders, and this is essentially for new attorneys or attorneys new to our district. Just a heads up on a couple of the pitfalls that we see from time to time. You know, the first are the minimum filing requirements. Assuming your case gets accepted by the clerk in the first place, if you do not have certain items as part of your initial filing, the court, sua sponte, will strike it. Those items are your petition for relief, your filing fee, or an application to pay those fees in installments, a list of creditors or schedule of liabilities, or a motion directed to the UST for an extension to file it, and if you're filing a Chapter 9 or Chapter 11, a list of the creditors holding the 20 largest unsecured claims. Okay, moving on, notice and opportunity to object. Everyone knows that we have a list under Local Rule 2002 of items that you can put on negative notice. That list is exclusive for the most part, and it is only those items that you can drop dead. However, the court can order otherwise if it wishes under 2002 sub E. Good. Okay. Also, you can put on negative notice under Local Rule 4004-1 a motion for relief from stay in a Chapter 13 if it's a surrender and if you state in the motion, the body of the motion, that it is a surrender. Service of process. We touched on this earlier, and everyone knows that service of an adversary proceeding and motions that initiate contested matters, and we usually focus on motions to avoid liens, but you should be aware that this is any motion that initiates a contested matter should be served pursuant to Rule 7004. So if it is a domestic or foreign corporation, that motion needs to be directed to the attention of an officer, managing, or general agent. And as was touched on earlier, if it is a FDIC insured institution, that service has to be by certified mail. And if you're wondering if an institution is FDIC insured, there's actually a website that can tell you that. In Chapter 13, this was touched upon as well. When you are making a request in your plan to value a secured claim, the service of that plan also needs to comply with 7004. Extensions to object to discharge. This is more for creditors that seek to extend time to object to a debtor's discharge. It is important that in the body, that you can do it in the body of the motion, you put a statement that there is a 14-day objection deadline to it. Verified motions for discharge. If you're in a joint case and you're moving to have the discharge entered, That motion, there needs to be 2 motions, one for each joint debtor, not just one under our local rule 4004-2. Motion practice. Any motion filed within a contested matter or an adversary proceeding needs to be accompanied by a brief. And our local rule also specifically provides that unless the court orders otherwise, the opposing party does have 30 days. There is a 30-day deadline to respond to that and a 15-day reply period. And if you don't, the court can rule on the motion. Moving on, discovery disputes. I think everyone knows that under our local rule, if you have a discovery dispute, you have to file a certification. Purpose of the certification, as we all know, is to say, hey, we tried to work it out, here's when we met, and here was the place, time of our conference, and the names of all the people that participated. Judge Grant already spoke to this, our local rule on motions for summary judgment, and he touched upon it, that your statement of material facts, our local rule provides that you have to have one. And this statement of material facts really is the heartbeat of your entire motion. So any fact you're going to rely on needs to be here, not in the brief, not in your reply brief. And in that, you need to be sure to, it is always helpful at least, to cite to the specific parts of the record that you're relying on. So if you have, X number of pages of discovery, it is helpful to cite to what page of that discovery you're relying on. Another point under our local rule 7056-1 is that if you are litigating against a pro se litigant and you're filing a motion for summary judgment in their case, there is a form you need to serve with them at the time you serve the motion on them, which sets out pretty much what's happening with the motion, what it is, and the response time and the reply time. Moving on, attorney withdrawals. I think everyone pretty well knows that you have to file a separate motion in both the main case and the adversary if you want out of both. You have to state the grounds in your motion, and unless the client terminated your representation, you need to have a statement in there that any response or comment to the motion should be made within 14 days. The motion has to be verified, and there must be some indication in the motion that your client was advised at least 7 days prior to filing it that you were going to file it. And lastly, law firms do not withdraw from cases. It is only attorneys. So just so you are aware, if you're trying to withdraw your firm, it may get bounced. Let's see, multiple forms of relief. I think everyone knows that unless it's alternative relief, you cannot ask for multiple forms of relief in one motion. For instance, you can't object to confirmation and move to dismiss the case all in one motion. And lastly, filing under seal. Again, the motion has to be accompanied by a brief. And so you're aware, in the Seventh Circuit, there is a higher bar. And the Seventh Circuit has held that general assertions do not suffice. I included a case cite in my materials where the Seventh Circuit said outright, such a motion would have no prospect of success unless it analyzes in detail, document by document, the propriety of success, providing both reasons and legal citations. So, I'm not sure how much time I have left to go on. All right, should I go on? Any questions so far about the local rules?
Or for any of us. Otherwise, he might go on.
No? Okay.
They'd rather listen to you.
I can burn 5 more minutes. I guess, unless you guys wanted to present your, okay. I included a couple notable topics, just so you are all aware of them. The first, 401k contributions. And these are just items where the courts are split, and in these cases, there may be only one or two circuits that have taken a position on them. The first, 401k contributions. So, as we know, under 1325B2, if there's an objection to confirmation, the court cannot confirm the plan unless the debtor has committed all projected disposable income to the plan. So prior to 2005, more specifically prior to BAP-CIPA, the consensus amongst bankruptcy courts was that wages voluntarily withheld as 401k contributions were part of a debtor's disposable income. Along comes BAP-CIPA and adds 541B7A, which provides that wages withheld as payment for contributions to an ERISA qualified plan are not property of the estate. So ERISA qualified plan, okay, 401k plan. But what Congress did is they also tacked on another hanging paragraph, which provides that except that such amount under this subparagraph shall not constitute disposable income as defined in section 1325B2. So the question has arisen in some courts, what exactly does that mean? And this usually arises in the context of an objection to confirmation under 1325, and usually a good faith argument will be raised as well that, okay, you're not contributing all disposable income, you didn't file your plan in good faith. But the question that courts have confronted with the statute is whether such amount, which shall not constitute disposable income, encompasses continued monthly 401k contributions that a debtor seeks to exclude from their disposable income in a plan. Or is it the amount excluded, the aggregate contributions a debtor made up to the petition date? Or does it mean something else? Courts have also struggled with the except that clause, and because except that is generally used as an exception to a generally applicable rule, and in this case, there's no logical connection between property of the state and disposable income because they are two different parts of the code and can kind of mean two different things. So there are essentially three camps. The first is courts that hold that 401k contributions can never be excluded from disposable income. There's another camp that that as long as you're making contributions in a period before you file, you can exclude them as long as you're not attempting to increase them or start them. And the other camp is you can make these contributions anytime you want, and they are excluded from the disposable income calculation. So what I provided in the materials were just a couple cases that kind of set this dispute out and where the courts fall. You know, the first is In re Johnson, which was kind of the first case. And what Johnson held is that debtors' disposable income does not include wages they contribute to their 401k, regardless of whether those contributions began prior to bankruptcy. And what the court also sort of addressed in that case was a good faith, and in the court's view that good faith is established if you're making the contributions within the limit allowed by the IRS. The next, NRA Prig, is on the other end of the spectrum, where the court held that under 541B7 does not authorize a Chapter 13 debtor to make voluntary contributions in any amount. And what the court did is that its reasoning was that because under 1322F, Congress created a specific exclusion for 401k repayments to a 401k loan, and did not provide did not do the same for voluntary contributions, that it deliberately omitted voluntary contributions and that they should be part of your disposable income. Moving on to Davis, there's a set of Sixth Circuit, and the Sixth Circuit is the only circuit that's addressed any of these. And essentially, in the Sixth Circuit, as long as you're making contributions in the same amount for the period prior to the filing of your petition, you can go ahead and exclude those contributions from your disposable income. Now, just this year, they issued another decision, Penfound v. Ruskin, 7F 4th 527. In this case, they tightened that up a little bit. In that case, debtor had, for 24 years, the debtor worked for an employer that offered a 401k, and during that period of time, debtor contributed to his plan, pretty much for the full 24 years. And that was up to 2017. In August of 2017, debtor began working for a new company. That company did not offer a 401k. He couldn't make contributions. In May of 2018, he began working for a third employer that offered a 401k. He filed bankruptcy that following June of 2018 and wished to continue making contributions and not include that as disposable income. And the Sixth Circuit said, no, you can't do it. And held that debtor cannot make contributions even if, one, the debtor had a history of making contributions in prior years when he was able, and two, even if the debtor was not eligible for a 401k in the months before bankruptcy. So you come to bankruptcy in the Sixth Circuit, you're not going to make them unless you've been making them prior to the 6-month period prior to the filing of your case. So, okay, quickly, the last two cases are out of our circuit. And, you know, again, they're diametrically opposed. NRA Red, 515 BR 586, and NRA Hall. In Red is essentially the Prig approach, where the court held that post-petition contributions are not excluded from the disposable income calculation, and that the hanging paragraph only includes contributions existing at the time of filing a case. Under their approach, what the court said is that all that does is up to the time prior to filing a petition, it affected your CMI. That's it. Going forward, you cannot make contributions to your and exclude them as disposable income. NRA Hall took a completely opposite position and held that not only are pre-petition contributions both accepted from property of the state and not included in the disposable income calculation, but contributions made any time are excluded from the disposable income calculation. And the court essentially put those contributions on the same footing as a retirement loan under 1322F, and held that any ambiguity regarding the exclusion of contributions should be resolved in favor of the debtor. So, time's up. Yeah.
In order to keep to our kind of early schedule, there's snacks and cookies and potato chips and pop in the back. If we can do this in 5 minutes, then we can come back and have the infamous Ask the Judge and Trustee panel. It could be fun. Okay, can everybody be seated, please?
Okay, this is our Ask the Judge or Ask the Trustee session. We want to thank you. We've got actually a total of about 22 questions here. We'll try to get to them all. We've got 45 minutes. We tried to go through them a little bit and rank them, and so we get a variety of different things. Let's just jump right in. By the way, if any of these sound like facts in front of the judges, they may say, yeah, I'd rather not comment, but I think we've kind of gone through that, so I think we've got that figured out. So,
if you have a question that you want to ask, raise your hand so Cindy can bring the microphone to you, please.
okay, here's our first question. We'll ask this of Judge Grant. If an asset of the debtor in bankruptcy is sold pursuant to the bankruptcy court's order, what is the effect of such sale on the lien of a creditor who has not participated in a bankruptcy in any way? Assume that the creditor received notice of the sale, and further that the bankruptcy court order states that such sale is free and clear of all liens, including the lien of the aforementioned creditor.
Okay. There are some that will tell you that a bankruptcy court order authorizing a sale free and clear is the cleanest title you can get. It erases everything. Actually, we've got a decision out of the Seventh Circuit. It was Chapter 11. The debtor was, among other things, a landlord, owned some grain elevators along a railroad siding and leased them to a grain elevator company. Debtor files Chapter 11. Rejects the lease. Not a problem. Grain elevator company, knew all about the bankruptcy, not unlike the hypo we've got here. And if you remember what the code says about rejection of leased property, where the debtor is the lessor, the lessee has the option of remaining in possession. It doesn't destroy the lease. It doesn't vaporize the lease. Rejection is simply breach. And the lessee can decide, I'm going to stay here. They still have to perform their obligations, but they can deduct whatever costs the landlord's rejection/default might impose, say maintenance costs, for example. Okay, so the grain elevator company looks at the bankruptcy code, their lawyers look at the bankruptcy code, we get to stay in possession, we don't have to worry. Debtor chooses to sell, gets an order authorizing sale free and clear of liens. Look at the bankruptcy code, we're cool, we get to stay. They'll be our new potential landlord, but we get to stay here. Property sold. Dispute then arises because the new owner wants to get rid of the debtor's lessee. Goes all the way up to the Seventh Circuit, and the Seventh Circuit said they had to object. I don't care, we don't care that the code allows them to remain in possession. That part of the code is trumped by 363, which allows sale free and clear of any interests, which includes the rejection interest of the lessee. So applying that wisdom, that teaching to this question, mortgage holder who had notice and doesn't bother to participate is SOL. Now the trustee is probably going to have to hold their share of the proceeds, and it's here if you ever want to come down. But the property is still gone and your lien on it has been transferred to the proceeds.
Okay, here's one that's a little more straightforward. Judge Ehler, when do I need to submit a proposed order with my motion? And what happens if I don't?
The answer is all the time. All the time. And it's a simple rule to remember that.
I'm sorry, I repeat the question. When do I need to submit a proposed order with a motion? That's the question. When do you have to, if you file a motion to do something, when do you submit the order?
Remember, the local rules say that any motion that initiates a contested matter should be accompanied by a proposed form of order. So,
And to further answer that question, if you don't, what happens? At least my procedure is generally just to give someone a friendly reminder or tell them that that order will be on file within a specific amount of time. I think the harder question is, after you have a substantive hearing, an evidentiary hearing, the question often comes, do you want us to file a proposed order afterwards? And most of the time, frequently, lawyers will say, I can tell they don't want to do it. I know that Judge Grant may have a different take on this. I find them exceedingly valuable, and I would always suggest you take that opportunity. And why do I say that? After you get done with your entire hearing, there is no better time, at least in my point of view, to submit a proposed order to give me your closing statement, if you will, to help persuade the court. Sometimes it's very helpful. Sometimes it's not. If you just get a court order that says motion granted for the reasons stated, that's not really helpful to me. You can do that and you can say I fulfilled my obligation, but I don't think that's not a best practice I would consider. Judge Grant and I have talked about this on several occasions, and we may differ.
and we do.
Yes.
At least in the latter scenario where we've had an evidentiary hearing, I'm willing to generally write my own order. If I want something, as Judge Ehler referred to, in the nature of a closing argument or something that would restate your position, I won't ask you for a form of order, I'll ask you for a brief. And then you can put your arguments there, but I'll grant your motion, deny your motion, or whatever, and knock out my own order, because sometimes we find that the orders that are submitted are not worth anything. Your motion is granted. If that's all you say, it's really questionable whether you've got a final order, because nobody knows what that order means. And that's the hallmark of a final order, that it clearly expresses the result without the reasoning, just the bottom line, what happened. And you've got to be able to tell within the four corners of the order without reference to other documents, other things. I pity trustees. Sometimes we see motions for fees that come in. So-and-so filed an application for fees. There being no objection, the application is granted. How much are they to pay? You got no idea. You can't tell.
On that point, I would also suggest that if you had a motion pending before the court for some period of time and it's been continued, 60, 90 days, or whatever that time may be aware that when the court finally is resolving that matter, that motion that you filed 2 months ago or 30 days ago might be stale. It may no longer have the terms that you're looking for, and then I will say, counsel, I need a form of order, and they'll say, I filed one. It's not the same issue that we're talking about, or if it's moved down the road substantially. So be aware of that when you're coming up for your hearing. Is your order still good? Does it still cover all the essentials you need?
I think as a practice point, it makes more sense to draft it and file it right then anyway. As Judge Grant said, we have a local order, but I always like to work backwards. What do I want to get? I want an order that says I'm going to do A, B, and C. So I want my order to say A, B, and C. Now I need a motion that gives the judge the facts to give me an order saying A, B, and C. So if you just kind of do it all as one continuous thing, upload it, and very often the judges will ask us as trustees, have you seen the order that's been proposed? Are you okay with it? Is there anything in there that's hindering? For instance, we don't know what the fee is we're supposed to pay, something like that. So,
by the way, when you do submit a proposed form of order, don't ask for anything you didn't ask for in your motion.
We can't?
We'll know. We hope we'll often notice, and then we get upset.
all right, here's I think a pretty easy one for the trustees. A Chapter 13 plan was confirmed in the middle of the month. When will the first disbursement go out?
Christmas?
Yeah,
We think.
Christmas.
Christmas. Generally, I know we actually disperse first, second, third business day of the month. So if it gets confirmed on the 15th of September, we close our books on the 30th of September, and then we disperse either on, depending on weekends and things like that, the first, second, or third.
And we do the same. Ours are mailed about a week after that. We sometimes have things come up, e-pays go bad, things. So we hold them a little while so we don't have to cancel and redo so many. So ours go out about the 9th or 10th of the month, but they're dated the 1st.
And if you're a debtor's counsel and you haven't signed up with our office for ACHs, silly you, because the money is actually sent out to the bank the day after we disperse, and that saves you 2-3 days waiting for a check, and the money's immediately there. So if you have a question and you want to get an ACH from my office, contact Cindy or Tammy in my office.
We have a hearing or trial coming up. How should I prepare my exhibits? How do I know if I use numbers or letters? And how many copies do I need to bring to the hearing? Judges, either?
Well, if you're familiar with our website, you'll know that a portion of it that's accessible under my name is answers to frequently asked questions concerning practice and procedure in front of Judge Grant. And one of those is just this: how do I prepare my exhibits for trial? In general, I don't care whether you use letters or numbers. What I do expect is that you will talk to your opposition and figure out who's going to use letters and who's going to use numbers. And if you both show up with numbers, I'm going to know you didn't do what you were supposed to do.
Right.
How many copies do you need? It's kind of a matter of obvious courtesy. You want one for the court, the official record. You probably want one for the witness. You want one for you. You ought to bring one for your opposition. I like to have one so that I can make notes on them, scribble without defacing the official copy, and the law clerk often likes to have one as well. So, what are we up to, maybe 6?
6.
How do you present them to the court? How many you got? You got 2 or 3? Not a problem. I can, handle them like this. You got 30? Would be nice to have them in a binder so I don't lose them with tabs that this is Exhibit 1, this is Exhibit 2. And you may even want to change colors on binders to make certain that somebody has white, somebody has black, somebody has blue, somebody has red, so that I know immediately whose exhibits are whose. One other thing, it's okay to share exhibits. You're having a fight over a proof of claim. It involves the promissory note. I only need one copy of the note. I don't care who introduces it. I don't need one from the debtor, one from the creditor, and one from the trustee, because they're duplicative.
Judge, you said something kind of unusual in there. You wanted the parties to talk ahead of that hearing? They could deprive you of that hearing if that happened.
And that's the goal. In all truth, it's generally more productive for you guys to talk to each other than it is for you to talk to me. You have something you wanted to say?
There's a question here in the audience. Is that okay?
Go ahead.
I'm running into more and more cases where the client pre-bankruptcy has an account at that bank, and the bank takes its house payment out, so the bank is administering and keeping records on house payments. And my question is, if the debtor wants to keep this arrangement up, and obviously they're current pre-petition, and wouldn't that provide more money to the unsecured creditors? And for example, I've had cases where there's a minimum distribution because they're over the exemption limit, like on a house. So wouldn't it be in the client's interest to continue this arrangement, because the bank themselves would not, normally I would assume, would not object at the end of the case with a notice of final cure? The bank themselves have the record that the debtor's current. So my question